This just in. New York State finally passed a bill authorizing the release of the Federal Emergency Rental Assistance Funds, with some caveats. If you're a tenant, you're going to be pretty happy with this bill. If you're a landlord, well, let's just say it's one big, smelly crap sandwich. It stinks worse than the sequel to that Gangnam Style song.
I'm a motherfucker gentleman.
Come to think of it, I actually kind of like that song. Alright, and the bill isn't horrible either. It definitely could have been a lot worse for landlords. I'm going to give you guys all the details coming up. Hey guys, if we're just meeting, my name is Vitaly Volpov. I'm a practicing attorney, an active real estate investor, and a part owner of a real estate brokerage in upstate New York. On this channel, I discuss relevant legal concepts as well as best strategies and tips for real estate investing and personal finance. If you're new to the channel, consider subscribing and hitting the notification bell so that YouTube notifies you of all my future content. If you enjoy the content in this video, hit the like button and comment down below. And as always, whenever I'm discussing legal or financial topics, just remember, nothing that I say should be construed as legal or financial advice. You should always consult with your own attorney and your own advisor before making any legal or financial decisions. Last but not least, the views and opinions that I express in this video are my own alone and don't necessarily reflect those of my law firm or any of my business partners. So like I said, if you're a tenant, you should be pretty happy about this bill. Unless, of course, you're a complete communist, you thought that rent should be canceled, and you should get to live in your landlord's property forever for free. In that case, you might be a little disappointed. But most sane, reasonable tenants are pretty happy with what the state is doing here. If you're a landlord, on the other hand, well, it's a bit more of a mixed bag. There are definitely good parts to this bill, and there are certainly some bad parts as well. Now, before I get into the good parts and the bad parts, let's first talk about the minimum baseline requirements one needs to meet in order to get rental assistance. Number 1, tenancy. This one is pretty obvious. A person needs to be a tenant or an occupant obligated to pay rent in their primary residence in New York State. Number 2, one of the following. A, someone in the household qualified or qualifies for unemployment. B, someone in the household had a reduction in household income as a result of the pandemic. C, someone in the household incurred significant costs as a result of the pandemic. Or D, someone in the household experienced other financial hardship due directly or indirectly to the pandemic. Number 3, the tenant can demonstrate a risk of experiencing homelessness or housing instability. And number 4, the household's income is at 80% or below the median area income adjusted for household size. So those are the minimum requirements. They derive from the federal law which authorized back in December of 2020 the appropriation of the Emergency Rental Assistance Funds. Now let's talk about the New York State specific changes. And landlords, tell me, would you like me to tell you about the bad parts or the good parts first? Alright, I'll be nice. We'll talk about the good parts first, and then we'll talk about the bad ones after. The good news is that, number 1, landlords will be able to initiate the application, apparently with minimal involvement from the tenant. Number 2, with regard to documents, it appears that a self-attestation from the tenant may be all that is needed in order to prove that the tenant qualifies financially and that he or she is at risk of becoming homeless if no rental assistance is provided. Specifically, the actual language in the statute states that self-attestation shall be considered to be acceptable documentation to the extent permissible by federal law and relevant guidance, provided further that attestation of a person with knowledge of the household circumstances shall be considered to be acceptable documentation to the extent permissible by federal law and relevant guidance. The final bit of good news for landlords is that they will be able to receive this payment directly. Now, we already expected this to happen because the federal law actually requires it, but it is nice to see New York State actually complying with federal law and not trying to do their own thing. So now, on to the bad news for landlords. Bad news number 1 is restrictions on evictions. If a household which could be eligible for assistance applies for assistance, then no eviction, whether for holdover or non-payment, can be started against that household until a determination as to eligibility is made by the state agency in charge of making those determinations. The holdover restriction in this new law, in my opinion, is completely asinine. It has no connection to whether tenants can or cannot pay rent, and it also has no connection to whether tenants can or cannot qualify for rental assistance. It is just a blatant overreach on the part of our legislature in their quest to, quote, protect tenants from nefarious landlords and in the process stifle private property rights. But it doesn't end there. If there is an eviction already pending against a household, whether for holdover or non-payment, and that household applies for rental assistance, the eviction proceeding has to be stayed until a determination as to eligibility for assistance is made by the agency in charge of those determinations. Okay, the holdover piece is pretty bad, but it doesn't even end there. Not only will you not be able to proceed with an eviction before OTDA makes its determination, but if OTDA determines that a tenant is eligible for payment, you will automatically be deemed to agree that you will neither raise their rent or evict them on holdover grounds for 12 months after you receive the rental assistance payment. Yeah, you heard that right. If you receive any amount of rental assistance, whether it be 1 month or 12 months, and even if you didn't apply for rental assistance and your tenant applied on their own, you will be prohibited from evicting that tenant upon the expiration of their lease. Or if the lease is already a month-to-month lease, you will be prohibited from ending their tenancy for the next 12 months. Now, as I read it, this is not a prohibition on non-payment proceedings based on your tenant's failure to pay rent going forward. So if your tenant fails to pay your rent, as long as your rent amount was the same as it was before they applied for rental assistance, you should be able to evict them. So when I said it could have been worse for landlords, I meant that the state could have prohibited all evictions, including non-payment, for 12 months after you receive your rental assistance. The fact that the state left the door open for future non-payment proceedings is certainly good news. In addition to restricting rent increases and evictions for holdover, you as a landlord will also automatically be required to forgive all late fees that may have accrued on the amount owed. Late fees are already unrecoverable in New York eviction proceedings under the prior law, but now if you receive rental assistance, you won't even be able to pursue the tenant in small claims court to try to recover those fees. You are deemed to have waived them in the course of receiving rental assistance. If this wasn't enough, you are also deemed to agree that all back rent is satisfied with the receipt of this rental assistance, regardless of whether you actually received the full amount owed. Remember, the maximum amount of rental assistance is 12 months, going back no earlier than March 13, 2020, when the eviction bans went into effect. So you can easily imagine a scenario where a landlord was owed back rent dating back to before March 13, 2020. Now they will not be able to recover that rent as a result of receiving rental assistance, and they will be completely out of luck for any additional outstanding rent. Additionally, it's also possible that OTDA will not even be able to provide 12 months of back rent to those who are owed 12 months of back rent. It's possible that OTDA will try to ration rental assistance when funds start running low, and some landlords will get a lot less than 12 months even though they're owed a lot more than 12 months. And even in those scenarios, those landlords will be prohibited from trying to collect any of that other remaining money from those tenants because they receive rental assistance. Certainly this doesn't seem equitable and it doesn't seem fair to landlords, but that is the law that New York State just passed. The final provision in this new law that I want to mention is the prioritization scheme for the first 30 days. This isn't necessarily a bad thing for landlords, but for the first 30 days, New York State has announced that it will favor certain applicants over certain other applicants based on financial criteria and other characteristics. So as the statute provides, for the first 30 days, this is how the distribution of funds will be prioritized. Priority will be given first to tenants who fall in the following group. Their household income is 50% or less of the median area income, and one of the following criteria is met. They live in a mobile home, one or more members of the household is a member of a vulnerable population, such as domestic violence victims, survivors of human trafficking, and/or veterans. They have a pending eviction. One or more members of the household is a member of a community that was disproportionately impacted by the pandemic as determined by OTDA, or they reside in a building of 20 or fewer units owned by a small landlord. After this group, priority will be given to those whose household income is 50% or less of the median area income, but they do not meet any of the criteria described in the first group above. The next group are those tenants whose income is 80% or less of the median area income, and one of those additional criteria described in the first group above is met. And finally, the last group is everyone else whose income is at 80% or less of the median area income and who do not meet any of the additional criteria described in the first group above. Once the 30-day period ends, applications will be received and processed on a rolling basis without regard to the criteria that I just mentioned. So I think at this point, some of you may be asking the million-dollar question: when will this rental assistance be available? Well, unfortunately, I am sorry to say that as of the date I'm recording this video, the answer is still we don't know. OTDA's website still provides the same information that it provided 2 months ago on February 19, 2021, and that is to say, they are working on it. One last thing that comes with this new law is that counties and cities that receive federal funding directly, like my home counties of Albany and Saratoga, can transfer that funding to the state and allow the state to handle the distribution and the application process. While this might create some uniformity in how applications are received, processed, and the funds are distributed, I do think that this may lead to delays for certain applicants who otherwise would have received the money by now. For example, some counties that receive federal funding directly may be able to process applications right now and to start distributing funds right now. But instead, if they transfer the funding to the state and allow the state to handle it, there may be additional delays because clearly the state is still not ready. So that's it in a nutshell, guys. If you have any questions for me, be sure to drop them in the comments down below. If you enjoyed this video, do me a favor and hit the like button. And if you haven't yet subscribed to my channel, definitely subscribe so that you don't miss any of my future videos. Thanks again for watching, and I will see you guys in the next one. Take care.